Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. A copy of the handout can be found in the handout section. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. The recording will be available on demand following the webinar. I will now turn the presentation over to your presenter. You may begin.
Thank you and good afternoon, SHRM, Long Island. This is Henry Shapiro. It is Friday, October 25th, and for those of you who had the privilege of attending Wednesday night's SHRM dinner at in Oyster Bay, Woodbury, I should say, at the mansion in Oyster Bay, where Chris Valentino spoke on some recent legal update matters, or if you had the privilege of attending yesterday's Long Island Breakfast Series at the Melville Marriott, sponsored by SHRM Long Island, where Chris and my colleague Tim Dominic spoke about several updates to New York and federal labor and employment law. You are now going to have the privilege of hearing a third voice beat it into your heads of what's important, what you should be paying attention to, and why it matters for your workplace, whether it's a New York City change, which for those of you who have been kind enough to dial in with me for the last 2+ years at this point and listen to me drone on about why New York City matters. If you were at the breakfast series yesterday, you heard Chris say the same thing. Everything, for the most part, there's always exceptions, everything in New York City eventually trickles its way down to the surrounding areas. That is Nassau, Suffolk, Westchester, and the greater upstate New York area. There's always some exceptions, and we haven't seen the Fair Chance Act out of New York City make its way out to Long Island yet, but it'll come. If I had to bet anything on it, it would come. Here, New York City is constantly releasing new guidance on discrimination and what is prohibited in the workplace, and obviously did a lot of work on the sexual harassment prevention, and a lot of it made its way stateside, outside of the 5 boroughs. So we'll talk at the end today, and there's fewer slides today because they're a little bit more dense each slide. So we'll talk at the end about some recent New York City changes and updates to independent contractors and their applicability with the human rights law, especially in the sexual harassment sphere. And we'll talk a little bit about some recent guidance on national origin discrimination and immigration status discrimination. So let's get started. And again, for any of you who already heard similar things to what I'm going to talk about either on Wednesday or Thursday, or it is your hobby to read up on Jackson Lewis's employment law articles, I appreciate it. We appreciate it, but you'll now have the privilege of now listening to me talk about it. So this weekly pay for manual workers, this was a big deal. And it's not something that probably many people thought would be a big deal. Why? Because there wasn't so much a change in the law. The law itself stayed the same. The law has always been on the books for, I don't know, close to 100+ years now. What changed is the courts. The courts, which we all know interpret laws. There was a recent decision in the first department, the appellate division. Out here in Nassau and Suffolk, we're in the second department, but it's all applies just the same. Whether or not it's persuasive versus binding, we could discuss, but it doesn't matter for this. What matters is that now New York State, an appellate court in New York State has spoken on the issue. So the law is manual workers, so those who spend more than 25% of their time engaged in physical labor. Those workers must be paid weekly. So for those who pay bi-weekly or semi-monthly, whether you get 24 or 26 pay periods in a year, it's not good enough for a manual worker that's doing 25% of their time or their work with physical labor. So those people must be paid on a weekly basis. You might have a handful, you might have none in your workforce, you might have an entire workforce of them, and maybe you're paying them wrong. And in your head, maybe you're saying, what's the big deal? They're getting paid anyway. In one way, shape, or form, they're still getting, for every minute they work, I'm compensating them in some fashion. Maybe it's on a lag, maybe it's 2 weeks later, but I'm paying them. Somehow I'm paying them. So what happened now is the First Department of the New York State Appellate Division, which is the kind of the next level up from the Supreme Court in New York. Courts here are a little bit reversed from the federal paradigm, where the Supreme Court in the United States is the highest court. Here, the Supreme Court in Nassau and Suffolk is the lowest court. It's where you start your claim. So, First Department Appellate Division held that a private right of action exists for the untimely payment of wages. So now, if you're paying a manual worker after they work 2 weeks and then you pay them at the end of the second week, you're technically not paying them that first week timely. So although it would make good sense, and I struggle to say New York ever does anything that makes good sense. Sometimes they do, but here, if New York is, with the court here, what they're saying is it's not just interest. So I didn't get my first week of wages timely. If I had it, I could have invested it and put it in the bank and made interest on it. So my damages are the interest. That's not what the court said. The court is saying now that they could recover liquidated damages. So they being the employee that was allegedly paid incorrectly, not timely. Liquidated damages is 100%. So 100% of whatever that first week's pay is basically that week's pay again. So you already paid them for the work, but because you didn't pay them timely, now you owe them basically an additional week of pay. So ultimately, you see the example. If a manual worker was paid $2,000 for the biweekly period, so let's say they earn $1,000 in week one and $1,000 in week two, and then they get paid $2,000 at the end, the employee now could recover an additional $1,000, which is what was earned in the first week but not paid timely. So that's quite the amount of liability. And this applies even though that the individual received his or her full pay. It's not about, you didn't pay me for the time I worked. It's you didn't pay me timely. So for anybody, again, who was at the breakfast series, heard Chris speaking about this yesterday, eventually, our prevailing wisdom here in Jackson Lewis, at least in the Long Island office, is that we expect cooler heads to eventually prevail, probably through subsequent court decisions. But we're not there yet. It'll take time to probably get there. So for now, we think there's going to be litigation on this issue. We've already seen it. If you have questions, if you're not sure, please, I beg you, reach out to your counsel. If it's us, we have several practice group experts here that I go to with my questions that are fantastic, if you work with Jackson Lewis, whether you work with Jeff Brecker or Noel Tripp or Craig Roberts, we have somebody who can help and figure out how to best move forward with payment. So, the overtime rule. This is a big one, and I many of you probably already know this, so I won't drone on too long about it. But I do just want to cover it to say that we talked about it. So the final rule, which is going to go into effect on January 1, barring any last-minute changes like we saw from a district court judge in Texas with the Obama rule in, I believe it was December of, at this point, 2016, feels like ages ago. Here, final rule now is, so we are finally increasing the federal salary level. This doesn't change much of the New York law, especially with the executive and administrative exemptions for the professional where there is no salary basis. We now have to be smart and consider the federal uptick in the salary threshold dollar value. But for all of you who have out-of-state operations where you have no New York State applicability, the federal law changing does matter for you. For those of you who solely operate in New York, you're still going to want to pay attention to this just for the effect that it's going to still have somewhat on your workforce, especially for those of you classify as professional employees where the salary basis is now going up because the federal salary basis is going up. So what's the new level for the white-collar exemptions? And again, these are the people that are generally exempt from overtime. That's what we talk about when we talk about exempt. The new salary level for white-collar exemptions will be $684 per week, or the yearly number of $35,568. So many of you probably remember from the Obama administration, the Obama final rule with the $47,476 number. Now it's $35,568, so lower, but definitely higher than the current federal requirement of $455 a week. $23,660 a year. So this is a little bit of a change from the proposed rule. It's gone up a little bit, $5 a week, so probably not a tremendous difference, but a difference nonetheless. The Obama proposed rule, as you see there, was the $913.47,476. So for highly compensated employees, so people who you are going to classify as highly compensated and try to fit them into the exemption, the level that you are all used to now is $100,000. The proposed rule for the Trump administration was much higher, $147,414, even higher when this was a little odd, even higher than the Obama proposed rule, just based on the change in administration. You wouldn't have expected this, but it jumped about $13,000 above what the Obama rule was proposing. So the new rule now is going to be 107, again, barring any changes, 107,432. So not 147, not 134, and soon to be no longer 100, just 107,432. No change to the duties test. That's a big one. This is, however, the most practical advice I will give you. In the event that you have always had concerns about the way you classify individuals and whether or not somebody is exempt or not exempt, or should be one way or should be the other way, now's a good time to consider an audit of job descriptions, to take a look at positions where you're not sure. Obviously, you want to look at everybody's pay, because that is what's changing. The numbers are changing as far as compensation, so you want to take a look at that. But what's not changing is the duties. But for those, I will tell you generally where this the three characteristics are the salary basis, the salary threshold, and the duties test. The salary basis, most of you probably have figured out. That's just you pay them on a salary basis. The salary threshold is the numbers. That's what's changing. The duties is not changing, but I will say that's where most often people go wrong and think that they have, because there's really no bright line rule. There's language prescribed by the Fair Labor Standards Act, by the New York Department of Labor and the labor law, but until it's tested in the courts, it's impossible, unless there's case law out on it already, to say that 100% this fits within this exemption. So everybody does what they think makes the most sense, but sometimes if you're not sure, there's safer ways to deal with it, such as classifying somebody as non-exempt if you're not sure, if they're on the border. So there will not be any automatic increases as far as the salary jumping, the salary threshold jumping over the next few years. So that's a difference from the Obama rule. The final rule will also allow employees to use their non-discretionary bonuses and incentive payments, so the employer can now use these extra payments that are outside of the base wages to get up to at least 10% of the new salary threshold. So again, if this is something where you're going to rely on non-base wages to meet the salary threshold, talk about it with counsel. Make sure that your bonus is truly non-discretionary. We run into a lot of issues with that. This is, again, going to take place in about just over 2 months, January 1, 2020. So what I will wrap up here with on the salary threshold piece is, if you have people who, again, this is mostly going to apply to non-New York State employers with operations on a federal level where there is not a higher salary threshold, or for those who are in the professional classification, because they are at 455, because that's the current test, but less than 684 being the new number. So if they satisfy the duties requirement, then what do you do with their pay? How do you fix this? If you're living on the 455 number, what are your options? So the easiest option, if you can afford it, that's typically most things, is sub-bullet 1. Increase the employee salary to the new level. Bring it up. Raise it. That's the easiest. The other options you could do, which is the other easiest probably, in my opinion, but the difficulty there is kind of the morale issue, is switching somebody from exempt to non-exempt and, tracking their hours when maybe you didn't used to do so. Now maybe they feel like, why did this happen to me? And what you don't want is to draw people's attention to, possible violations that you might not even have been aware of. So if this is a switch you're doing, there's right ways to do it, and that can hopefully be smooth and kind of fly under the radar somewhat. And there's wrong ways where, you don't want, you want to go on the offensive somewhat, but you don't want to convey it in a way that is going to make an employee feel that you are getting one over on them. So it's a very delicate discussion and process, and you want to do it where you're not singling anybody out, but we figure out what positions where there might be risk, and maybe we have to, either they're not able to make enough, we can't bump them up that high, we have to move them over from exempt to non-exempt. Perhaps you want to consider somebody a salaried non-exempt worker where you're still tracking their hours. But the key here, especially because of the amount of liability that could exist if you don't classify somebody correctly and properly track their hours and pay them overtime, is that middle one, is you want to be careful with overtime, because that's where the claims come in. You get somebody after their employment ends saying, you classified me incorrectly, you should have been paying me overtime, I was working 60 hours a week, guess what, you owe me a ton of money now. That's where the scary part comes in for employers. We already talked about how this must match up with the state laws. Again, you're still going to be subject to the higher state figures for New York, the $50,700 for executives, and for administratively exempt people, professionals not having the salary threshold. So moving forward, quickly on this, because of course, I said this is dense and I'm running short on time. Just, we had the cute name of the customer is not always right when discussing this internally, but third-party harassment, discrimination, so things to keep an eye out on when you have customers could be the harassers. It doesn't always, and if any of you underwent training either with me or with any of my colleagues, you'll know that one of the anti-harassment training pieces that was covered was the fact that anybody could be a harasser and anybody could get harassed, and you really got to be very vigilant and judicious with your policies. So we had a recent case coming out of the Seventh Circuit, which is in the Midwest, covering Illinois and a couple of other states, but coming out of the Seventh Circuit, where it was alleged that a casino failed to protect their female staffers or female workers from sexual harassment by patrons, by customers, people gambling or enjoying shows, whatever the case may be. But you can't have your employees harassed, even if it's by a third party. So while employers do not have the ability to control their customers' or vendors' actions, I think we all understand that, Title VII of the Civil Rights Act requires employers to provide their employees with non-discriminatory working conditions. Employers are liable for third-party harassment if they unreasonably fail to take inappropriate corrective action reasonably likely to prevent the misconduct from occurring. So that's a 2008 case. So now the point is now the EEOC is taking it more seriously. They're looking, especially with the Me Too movement and the agenda to weed harassment, especially sexual harassment, out of the workplace. The key here is to remember, one, it need not only be sexual, it could be any protected category-based harassment, and two, that an employer can't bury its head in the sand if it has reason to believe that customers, clients, vendors, delivery persons are violating their policies. The employees must be protected. And again, you'll see there at the bottom that the conduct need not be sexual in nature. Here we just dealt with a customer that was stalking an employee. That was enough in a case brought by the EEOC against Costco. So last two slides, and then we'll wrap this up. New York City, I said earlier, keep an eye on New York City always. Why? Because what they do typically finds its way out to the rest of New York State, especially Nassau and Suffolk. The City Commission on Human Rights has released guidance reiterating the obligations of employers to avoid, and this is again just New York City for now, but these are good guidelines to follow or to look at if you're not sure on what you can and can't do. Just because it came from the City Commission, they are really best practices for Nassau and Suffolk employers as well. But it's focused on national origin and immigration discrimination. They've done this for disability, for race discrimination, for criminal background. The EEOC will often release these kind of materials to kind of clue employers in. That's the EEOC. New York City is usually not far behind. They are not all that different, with the New York City Commission on Human Rights being more aggressive. They release usually more in-depth guidance. So what does the guidance say? I would venture to guess most of the people on this webinar already know and understand all of this, so you can't treat anybody differently, with the few exceptions for accommodations that I'm sure you're all aware of, whether it be disability or religion or pregnancy, etc. But discrimination or harassment in favor of U.S. citizens over other work-authorized individuals is generally prohibited. Questions about work authorization must be made in a non-discriminatory manner. All hired employees must be treated in a non-discriminatory manner. So what do you notice here? Don't selectively do things based on what you perceive or what someone's national origin is. Get the same I-9 forms from everybody. Ask everybody the same questions. Don't start picking and choosing who you ask what to, because that only opens up the groundwork for a potential claim from the employee who's getting more intensely questioned. Undocumented employees, if you hire them, they are covered by the city human rights law. Your defense is not that, oh, they shouldn't be working here, so I can do whatever I want to. That's not the intent of the law. Last piece, and then we'll wrap this up. I apologize for going over. The New York City Human Rights Commission also came out with information about independent contractor coverage. Very simply put, we can summarize this. Independent contractors can violate your policies. They can also have potential claims under your policies. They will count towards, if you read the second bullet point, they will count towards the calculation of your workforce. Natural persons working as contractors and furtherance of the business enterprise count towards the threshold of getting the 4 employees for coverage. And for sex-based harassment claims or gender-based harassment claims, the 4-employee threshold does not matter. So just some clarified protections. I'm going to venture to guess that most people already made sure to protect independent contractors. Things you want to think about, possibly, is it worth training independent contractors? Should you give your policies to independent contractors? All things to think about. It's going to be a fact-sensitive inquiry. It's going to depend on how much work you do with this person, how long a job might be. So it's things to think about. If you're not sure, again, contact counsel, think about it. But I want to thank everybody. I apologize for running a little bit further into your Friday than I usually do. Thank you, everybody, for joining. Have a wonderful weekend, and we will talk to you in November, and have a happy Thanksgiving and a happy and safe Halloween. Take care, everyone.